everyone and welcome to Obedient Family TV, the program that Hope Alive. Yes, hope there, no matter the situation, no matter anything we be say they happen, whether from the executive, whether from the legislation, whether from the Supreme Court, hope there for Nigerians, because if we don't lose hope, now be say everybody go japa now. So welcome today on a good morning, afternoon and evening, depending where on they watch us from. We don't come today, make we come talk some better issues where we say if they come up this time around. We dey hear plenty people, they give different information where we want to do fact check inside. Then talk say, some of them they talk say Tinubu don't win for US court. Some they talk say ABI no go release this thing. Then talk say court orders ABI not to release information today will be the final day. But we don't do the fact check and the thing where we won't carry come. No be so. All those information where they fly around now false information. And we won't let well-meaning Nigerians know the information where ABI talk say they go give. Then talk say now by the end of October. And today na 31st of October 2023. And today be the last day. We will give you now the update where we say it they happen. Both all the filings where they happen for court and other things where we say it they follow. And the misinformation where they go around, where it they come up from and waiting be their motives, we call them the wellers. With that very one, not only me go talk all this one for inside studio. I get Angel for studio and I get Esther.
Good day, my well-meaning Nigerians, my lovely and intelligent, obedient worldwide. Welcome. Tell your neighbor, say hope day, but not in our leaders, but in God. They said court is the last hope of the masses. But my question is it truly the last hope of a common man? My take na hopelessness. But with God, all things are possible. Come on board, let's discuss.
Greetings to my well-meaning, obedient and wonderful well-meaning Nigerians out there. My people, I don't see as everything they go. Well, all hope is not lost. We still have hope and confidence that new and better Nigeria we are looking for is still achievable. Join us on this discussion. Welcome.
Join us as we enter the discussion wherever you join us from, whether you join us via Zoom or you join us via comment section. Make you like, thumbs up, make obedience worldwide. No, make them get confidence and make them know say the new Nigeria when we dey talk no be for us to stop. The people were there for the other side, they won't make we stop. But we no go stop. Because when we stop, now we say hope no day again. So we must continue every day to dey follow the things as they take waka go. So make I start with this false information, I be misinformation where we say it they go on. We get this one where they talk say breaking. US court refuses request seeking to release Tinubu's ABI record. It no happen like this. No court in the United States have sat on this very matter to refuse the request seeking to release Tinubu's information. There is no such court order existing anywhere. So we want you to disregard this very information as being false. Now, let's get to the major issue right quick. What the court, what Tinubu from the defendant side, which is the government agencies, what their response is that people are misinterpreting is what you are seeing on your screen. It is called the defendant response to plaintiff's motion for reconsideration. The defendants are the executive office for U.S. attorneys et al., which comprises the CIA, the DEA, the FBI, the IRS, and other relevant government agencies, about 7 of them. So this is their own response to what Aaron Greenspan and David Hundein are sending for court to make a reconsideration. Bearing in mind that this very information, this reconsideration is for time bound. They were talking about the timing of court because of the Supreme Court judgment. But the Supreme Court judgment has come and gone, but the battle is still on. So first, they said the Federal Rules of Civil Procedure 60B is not available legal basis for plaintiff in request reconsideration at the prejudgment stage of the litigation. By its item, Rule 60C provides relief only from final judgment, orders, and the proceedings. It does not apply at the interlocutory orders such as motions for hearings as applicable here. So they say so many things that I want the producer to scroll up and get to the point of their matter, their response. What is interesting in this, their response, because if I start reading it, we'll be killing time. There's much to discuss. So what is most interesting of what they said is that they did not say they are going to bring out Tinubu's responsive files. They are now saying they are going to bring documents. They are going to release the files that are not responsive to Tinubu's criminal records. So whatever that means for them, whether they want to bring out information that does not relate to Tinubu's criminal records, that is yet to be seen. But they have said here, they are informing the court, they are bringing it to the court. And inside this very same document that is circulating from the defendants, they are equally saying that they are going to do this as promised by the end of today, being the 31st day of October 2023. So definitely LBI is going to release the information that they said they are going to release today. So everybody should know that the release of the Freedom of Information Act is imminent today. It's going to happen. So I just want us to know that. Now, let's go to the major response to this thing that they have said, that they are not going to release the responsive documents or criminal records of Bola Tinubu. That is what they are bringing before the court. So I'm going to ask the producer to take us to the plaintiff's reply in support of motion for reconsideration. Now, this is the one that is the response to the one they just said, what they just said. We just finished. So I'm just trying to, make it very brief so we don't stay too long here. So this is coming from Aaron Greenspan and David Hundein. And I want all the viewers to understand that Aaron Greenspan is acting pro se here. Everything is written here. He is doing it by himself. He is representing himself. And there is no other lawyer that is paid to represent him, meaning that he is the one handling this. So this is the man that is carrying the burden of exposing the president of Nigeria, so to speak. So let's start with what he wrote to the court just in. This is the last thing that has gone to the court. The court has neither reacted on it, the court has not ruled on this, and the court is still, it can take tomorrow, next tomorrow, whatever it pleases. But the point is that there is an agreement that FBI is going to release these very particular documents ending today. Now, defendants' response to plaintiff motion for reconsideration pursuant to Federal Rules of Civil Procedure 60B is at turns false, misleading, and ridiculous. And is so often the case. The government defendants represented by the Department of Justice afford absolutely obsessive attention to procedure, except when it comes to Freedom of Information Act deadline. Yet, get that procedure wrong in the process, while totally ignoring substance, thereby rendering justice to no one. The government defendants begin by admitting that plaintiff's request is at least in part substantively correct, that the court did make numerous factual errors in its October 23, 2023 memorandum and order. All parties agree that those errors should be corrected. Defendants' position apparently and surprisingly diverge from plaintiffs, where plaintiff alleges facts under the heading defendants already agreed to produce responsive documents starting this week. Now, given that defendants admit later in their response that the only party that has acknowledged responsive documents that are not subject to an exception and will be produced is the FBI, who will produce records not related to Tinubu without ever specifying exactly when those documents will start to be produced. The source of disagreement must be around whether the words end of October refers to the last half of the month or, as now appears to be the case, October 31st being today at 11:59 p.m. in whichever far-flung time zone affords defendants the most time. A ridiculous interpretation. No reasonable person will believe that the end of October refers to October 31st only, especially when defendants could have specified an exact date forehand. Plaintiff and opposing counsel for defendants specifically addressed this issue on September 12, when Mr. Liebman told plaintiff by email, "I will advise the agencies that should their production be ready before the agreed upon anticipated dates set forth in the joint status report, they should not wait and they should produce as early as possible." End of quote. Now, defendants' argument about Federal Rules of Civil Procedure, Rules 60B, being in opposite for relief in this instance is moot. The court's order did have final effect, for it allowed the Supreme Court of Nigeria to issue a final judgment regarding the election of Bola Tinubu, unchallenged by documentary evidence that should have been released within 20 business days of plaintiff's Freedom of Information Act request per statute. But even if defendants take a different interpretation of what final means, and even if defendants refuse to recognize what may be final outside of United States borders, and even if the final resolution of plaintiff's request for a hearing is not the same as a final resolution of the multiple Freedom of Information Act claims in this lawsuit, Federal Rules of Civil Procedure 68 states, in quote, "The court may correct a clerical mistake or a mistake arising from oversight or omission whenever one is found in a judgment, order, or the part of the record. The court may do so on motion or so on its own, with or without notice," emphasis added. Plaintiff is a pro se litigant. Like I said, he's doing this on his own. Defendant's counsel is an experienced attorney who has represented multiple government agencies in federal court throughout his career. To nitpick at which section of Rule 60 is invoked when one is clearly appropriate and either may arguably be properly invoked, all in a failed attempt to make defendants' unlawful behavior and intrusive appear valid, is a waste of everyone's time, including the court's time. So this one a big grammar, but all the thing where they talk here, I believe say our people go understand that. We will go to the end. We're there for page 3. And this very one, now thing where we say they don't file, the counter waiting United States agencies like CIA, FBI, and co. they do. So he said, filing the instant motion, plaintiff was not seeking to re-argue his positions, which the court already has ruled. At response number 2, plaintiff was never afforded the opportunity to make any argument in the first place which regard to a request for a temporary restraining order, because that is not the type of request that plaintiff filed. And the relief that plaintiff did actually ask for, a hearing, was denied. Defendants cite no precedent suggesting that requests for hearing are properly construed as requests for temporary restraining order, offering only their own legal conclusion. Nor do defendants even attempt to identify who is it they think that plaintiff was supposedly trying to restrain. No one. From what action? Nothing. It is false that plaintiff sought to require defendants to produce documents earlier than what the parties has agreed to. See response at 2, because when plaintiff filed the instant motion on October 20th, 2023, it was already within the time frame that defendant has agreed in their September 11, 2023 joint status report. Again, had defendants wanted to commit a specific date in October, such as October 31st, they had every opportunity to do so. They did not. It is also false that none of the parties has considered any FO, that is Freedom of Information Act exemptions. Response as 3. Defendant Internal Revenue Service had considered in writing, although counsel has been skittish about filing this on the record, that it is prior invocation of exception 3 was based upon incorrect reasoning. Citations observed. The other Freedom of Information Act exemptions cited by defendants are also similarly based upon incorrect reasoning, most notably because any purported personal privacy invasion involving Bola Tinubu is not unwarranted, given that he is the nominal president of a country of over 200 million people and also an alleged criminal with a history of money laundering activities who forfeited $460,000 to the United States government. Citations added. Now, Bola Tinubu, the nephew, demonstrating that the nephew of Bola Tinubu, Jibril Adewale Wale Tinubu, a businessman in Nigeria's oil sector, appears in the Panama Papers, Paradise Papers, and Pandora Papers. The fact that Tinubu is an alleged criminal is already a public knowledge, courtesy of defendants themselves, making his purported privacy interest in that fact zero. Tinubu cannot claim a protectable or any privacy interest in something that is already widely known, the prior knowledge of which is the reason plaintiff have any impetus to file this lawsuit at all. The less obvious privacy interest in keeping secret the fact that he was the subject of an FBI investigation was diminished by his well-publicized announcement of that very fact. Citations quoted. Now, prosecutor's public acknowledgement that he was subject of disciplinary proceedings undoubtedly does diminish his interest in privacy. The public already knows who he is, what he was accused of, and that he received a relatively mild sanction. Citations pointed. Now, Tinubu has openly discussed his investigations before courts in the US and Nigeria. It is also false that plaintiff does not even contend, let alone establish, that the public interest outweighs the privacy interest or that the equities favor his position. Response as 3. The instant motion does, in fact, include such contentions pointing out that Tinubu's action or inaction can affect millions. Motion at 9. The interests of millions of people are inarguably mathematical superior to those alleged criminals who claim to have won a contested election. To the extent defendants are relying on some metric aside from a numerical comparison to suggest that Tinubu's purported privacy interests are superior, they do not identify one. The agency bears the burden of establishing that a claimed exemption applies. Citations supplied. The FBI and the DEA invocations of exemptions B6, B7C are similarly ridiculous, as it is the suggestion that it cannot be confirmed whether records even exist. First amended complaint provides the specific internal FBI case number and time frame for the records such. FBI case number IP 71386, I think 6 years. During the time frame of 1992 to 1993, the FBI does not assign case numbers for fun to records that do not exist. Therefore, responsive records exist. Pretending that they do not is a pointless endeavor. The case number is valid. Now, defendants argue plaintiff entirely misapprehends the joint status report. Plaintiff admits that the initial complaint in this action contains a typographical error as to the Muaz Adeboyega Akinde's case, file number 39, which was actually assigned to Freedom of Information Act reference number 158765400. Citations added. This typographical error unfortunately carried over to First Amendment complaint from here. All parties failed to correct the error and carried it over to the joint status file report 5 September 11, 2023, which was then referenced in number 6 of defendant response to the instant motion. Finally, plaintiff notes that defendants EOUSA's October 27 response, a letter stating that a search related to responsive records regarding the above subject does not make clear whether records exist or not, or whether defendants EOUSA is invoking any exemptions or exclusions that it believes entitled it to withhold records. As the letter states, this response is limited to those records that are subject to the requirements of the Freedom of Information Act. Defendants EOUSA's interpretation of records that are subject to the requirements of the Freedom of Information Act may differ considerably from plaintiffs. In conclusion, the court should grant the reliefs requested in plaintiff's motion insofar as it is contemplated by the Federal Rules of Civil Procedure 60B or 60A, dated 30th October 2023, respectfully submitted, Aaron Greenspan, signed. Wow, what a marathon. Back to the studio. It's really very, very important for us to understand why we had to take this very marathon reading of this very particular response from Aaron Greenspan. Very important, because everywhere around the world, most people are misinterpreting that FBI is no longer releasing these documents. Nada. It is not the case. The important thing as at this moment is that the world all over are waiting to see the criminal records. The criminal records, as promised by LBI to release. Now, LBI is coming last minute to play some fine tricks about not bringing out responsive document. But the argument that you have seen, we have read out, is trying to be clear that since they have a joint status report, and in this joint status report, it was agreed that they are going to release out of the 2,500 responsive files, pages, they are going to bring out 500 every month, starting October ending. Now, the question and the issues they are having right now has to deal with when is the end of October. Greenspan is saying October ending can be from the 20th. And it must not be until we get to the 31st, which is today. That is the point. He was racing against time to meet up with the Supreme Court's judgment in Nigeria. But he was not able to beat that. But that does not mean that any court in the United States have sat or have refused to release the criminal records of Bola Tinubu. And he also argues inside that the criminal record, the privacy interest, both FBI wants to cite or that Chidi wants to cite, that is no longer private, that is a public document, that him has to find it from the court to be able to file for the Freedom of Information Act. It means it's a public document and it is already worldwide, but he wants it to get down from what happened as at 1992 to 1993. Those criminal informations as recordings and every other thing that they have on President Bola Tinubu. So that is where it is. So wherever you see a headline that says that a United States court has refused to allow a production of those files, it is false. Fact check that we have done reveals no court has sat on that matter to say that such information should not be released. That is the fact of the matter. So coming back, Angel, as he says, since I've been, running the marathon race, as in, running my mouth, running my mouth and all of that, but trying to get our audience informed so that they know that there's a fact check and this information is still expected. We are coming back to what David Hundeyin tweeted. Of course, he's not so happy about how it went so far, and everybody is not actually. So what is your take on this? So we proceed.
The thing be say, it's also good. Say our time difference, 6 hours difference. So make una no lose hope, because maybe by evening, 9 be their morning. So the thing go still come out. Since they don't reduce them from 2,500 to 500. Whether we go get them, we go get them. My people, no lose hope. We go get them, we go read them. The only thing where be say, around Greenspan won't do be say, he won't release everything before the Supreme Court. But I not say they are wayo too much, their corruption too much. They can't put the court under 2 days. But no problem, me una no lose hope.
Yes, you have your own distinct contribution, so we can go to the next thing we have online.
Well, definitely the file is going to come out by the end of today. Definitely is going to come out, and we are expecting, the best from it. We are expecting something very, very nice from it. Exactly.
So going back, we understand that now that we've let people understand that fact check is very clear on Tinubu's files are still coming out, whether they are bringing out the responsive ones or they are not bringing the responsive one. I think that very one is now left for the court to decide what they agreed on as at their last status report, so to speak, as they call it. So moving forward, let's get to what David Hundeyin felt about this whole things going on. David Hundeyin said that in October of 2022, Aaron Greenspan and I comments and a Freedom of Information Act request process regarding Bola Tinubu's extensive criminal records with U.S. law enforcement. Over the next several months, we work diligently and in silence as the case made its way through the Freedom of Information, rejection, appeal, and subsequent court processes. He said, I had every opportunity to let the world know what the case and our work on it, but I had always understood that the one superpower I have as an independent investigative journalist is the ability to move in silence and carefully manage information. The extent to which nobody knows how much I know is the extent to which my work has power. In May, someone decided to do a search of cases involving Tinubu's name on PESA, the public at U.S. courts database. They came across our lawsuit, which was still in its adolescent stage at the time, and decided to publish it. I checked Twitter one afternoon, and lo and behold, the details of this lawsuit, which I have been quietly funding out of my personal PayPal account, splashed all over Twitter in the name of journalism. From that moment, Tinubu's people were effectively given advance notice to pull out all the legal, political, and diplomatic tricks in their arsenal. This was the exact reason why I did not publicize the case when we started working on it. But PESA is a public database, and the inability of other people to keep their mouths shut is not under my control. After having initially stated unambiguously that it would comply with our Freedom of Information Act, clearly titled Bola Ahmed Tinubu and K.O. Tinubu, and after we filed the lawsuit, the LBI today has walked back on its position and now claims that it will only release documents not directly mentioning Bola Tinubu. Of course, it is impossible to prove that manner and extent of political interference and lobbying has taken place here. But what I do know is that we never had these problems until Nigerian journalists who were not involved in the case, who made no effort to investigate Tinubu's background until they saw an opportunity for cheap glory hunting, involved themselves and destroy the one advantage we had: stealth. My 1 year plus of hard work and financial commitment have just gone to waste because some people need for loud headlines was more important than anything else. Thank you. He said, "Una don try." Now, so the people will be saying they don't try. They don't try be that one. That very try will be saying, "Una don't try, una don't try." So what do you mean by saying, "Una don't try"? The person will go begin to expose this case where he starts. The person know himself. Exactly. You understand? So you will be say, David Dunde in the talk. Wherever you go, you know yourself. You know how you expose this thing. And that's why the battle can't be very tight. Because waiting David Dunde they explain by himself, they explain, say, this very something. Now, if to say somebody no begin they talk all this while, yes. Say Tinubu no go begin they come out, they spend all this money, begin they fight. By now, these people no go talk say, they no go bring the one where Tinubu name do inside. Because if we know when they talk about 2,500 for that September when they talk then talk clearly say now Bola Ahmed Tinubu. You understand me? So when they go talk now, talk say the one where name no day. You understand? Yes. So that's why I was trying to clear our people that it's false to state that the court has denied or refused to release those documents, but because it has been agreed that they are going to refuse it from the court information that we have. So they are only trying to say, hey, we are not going to bring the one that has his name. So maybe they are going to clean out his name, we don't know. Or are they going to give us the one that contains Adebo Yiga, or the one that have K.O. Tinubu, or Halahaji Magaji, you understand me? Either way, this is just to clear some certain things that are remaining from this very journey so far, is to clear it.
No matter what I believe is nothing is hidden under the sun. No matter what. Obedient people have started it. David Hundeyi have started it. And we are going to complete it. Whether this year, whether in 3 years coming, whether in 4 years coming, the truth must surely come out. You cannot cover a pregnancy, no matter what. At the 9th month, baby must come out. No matter. Since 1999, the public domain, like as it did 2023.
Obedient make that
of course.
Make that happen.
So many people don't even know about it in that 1999. But look at it today. Everybody, so far you get internet for your phone and you are concerned about democracy in Nigeria, you must read about it.
And that's why
it's a big plus for David Hundeyi. It's a big plus for Obedient Movement. It's a big plus for our HPO. Yes.
Yeah. So make the no
we should not be down.
Make David Hundeyi know they too down.
Exactly. It's not a waste.
Make you know be say the thing where as you take talk, the thing where you do, you don't show the world. People will never know him before.
Even me, I don't know him. That's 1999.
So they don't know him now. You understand?
Yeah.
And now we know that Tinubu has some criminal background and dealt heroin.
So many baggages.
We now know that Tinubu submitted fake certificates. We now know, you understand me, courtesy him, bringing out the facts before everybody to see.
Yeah,
very important.
You should not flog him.
Now, okay, a way, I believe by now everybody who wake up should know that anything circulating outside of the fact that those documents from those files from FBI must be released. Whether they are redacted, Tinubu's name we wouldn't know, and court has not ruled on that. So moving forward from Tinubu, let's get to what is actually happening in Rivers State. A lot. Wike is being the minister of Abuja FCT, and he is now trying to also govern Rivers State in proxy. You understand?
Yes.
In proxy. I think Maxwell, has not joined us on Zoom, or I think he's having some difficulties. But let's take a listen to what Maxwell has to do. We have some recorded something he posted that we want to share before he joins us later on. Let's take a listen.
Having a fight, and people are already taking sides. Some people. So it's already in the news that Sim Fubara and Wike are already having a fight, and people are already taking sides. Some people are supporting Sim, others are supporting Wike. The odds, of course, are very high. People are already staking bets. It's beautiful. But let us look at it from the flip side. With all this fight between Sim Fubara and Wike, Godfather, Godson fight, who is really suffering it? The democracy is suffering it. The rule of law is suffering it. 23, from the information I'm getting, of course, 23 local government chairmen have been removed by the governor of Rivers State, Sim Fubara. No due process, no accountability, absolutely nothing. These are people who were supposed to have been voted by the people of the state, and they've been removed. Now, recall also that these people were installed by Wike without due process, of course. That is the life we see with these guys. Let us look at another one. The chief judge of Rivers State have also been suspended or removed. This is exactly the same thing we saw with Buhari, who went all out against Walter Onogen. And there is news that this particular chief judge is playing to Wike's tune, or whatever you may want to call it. What does it link to? What does it tell you? Recall when we were talking about the rot in the judiciary, and the roles that Wike plays when it comes to the corruption in the judiciary. You won't hear it from my mouth, but I'm sure you know. Now, we listened to Atiku's, we saw Atiku's press statement today, how he said that the whole thing belongs to Nigerians. He has done what he wants to do, all his journey and travels through the Nigerian judiciary, both the one in America, the Supreme Court, and everything that rests on us. Let me remind you what Justice Musa Datijo said during his valedictory session while retiring from office as a justice of the Supreme Court. Recall that this man was, during the time of Tanko, he was third on the list. So now in Ariwo last time, he became second on the list. He was among the 14 justices that wrote that letter and signed against Justice Tanko, accusing him of mismanagement of funds, just messing up the entire judiciary. Now, Ariwola came into power and Datijo was retiring, and he's already talking about the same thing. He mentioned about Ahmed Lawan's case and Hope Uzodinma's case about how the judiciary was made, a jamboree, and people just sees the judiciary as basically nothing. I'm just saying this to just remind you guys that it boils down to the fact that our democracy by the day is draining, and this is what actually holds the existence of Nigeria. Datijo also said, what he was saying, he said before a country finally dissipates, before an entity finally dissipates, that what happens is that first, it first of all overlooks evil. From overlooking evil, it then permits evil. From permitting evil, it now legalizes evil, like what we've seen from the Supreme Court by its shambolic judgment of the presidential election petition appeal that was brought before it. And then you now begin to promote evil, which is what we are seeing in Rivers State. Promotion of evil. It has come into Abuja with Wike being the what do you call it again? The Minister of the Federal Capital Territory. Of course, what do you expect? And it gets to a point that it begins to celebrate evil, just like Nigerians are already celebrating the fact that a chief judge has been removed from office without due process. Or people are celebrating that 23 local government chairmen have been removed from office without due process. And it gets to a point that we begin to persecute the people who speak against evil. A lot of people have been persecuted. I won't be shocked if I am persecuted. But the truth is, we are by the brinks. We are just simply hanging by the web of a spider. I don't know how to call that. But except we realize that the power belongs to us, except we wake up to that reality, there's really nothing for us. I'm telling you the truth. There's really nothing for us. Because at this point, there is a reason why the judiciary was considered the last hope of the common man. Last hope? Common man? Is it still the last hope of the common man? I see it like the lost hope of the common man. So the common man has now become his own last hope. And except you take your country, except you remove these rascals who have been given judicial powers, legislative powers, executive powers. Let me remind you, there is a style of government that is called kakistocracy, where you allow the most incompetent people to lead over you. So we have a person who does not have any verifiable academic record, forged documents, criminal case, forfeiture of $160,000 as proceeds of narcotics and drugs trafficking and money laundering. We have him there as president. We have the one in Lagos State, sworn allegiance to another country, and all of that. But we don't seem bothered. We are not really concerned about where Nigeria is headed to. It's unfortunate. I wish Nigerians can realize that there is actually no future at this point. There is no future. The court told us that spending over 300 billion on electronic transmission doesn't matter. It doesn't matter. What do you need?
No future for the renewed hopelessness. But there is hope for Nigeria. Yes. If we continue to put up from the gains that we had on the last 1 year, a new Nigeria is clearly possible. It is up to us to continue on those gains and to strike. Just imagine somebody who is just in US, a US citizen who probably has not been to Nigeria before, but is holding Nigeria. I mean, he's going extra mile to make sure that he brings something out for Nigerians. And whenever he's writing to the court, he does not fail to mention 200 million people needs to know that the person who is leading them is an ex-criminal. I don't know about now, but it's very important that we have people like that. And also coming to the part of Nigeria here where we are, we have to take our own thing. Like Maxwell said, we have to take our country back. We have to do it in a very civilized way to show that a new Nigeria is possible. So looking at what is happening at Rivers State, we know we know the 23 local government chairmen were sacked. You understand me?
The chief judge was removed, and also they dissolved the state executive council.
The chief of staff was also sacked.
In fact, so many things happened yesterday in less than how many hours, and even the state assembly speaker was also removed too.
Yes, they impeached him.
So you know, the earlier we take this country by force, the better for us. Because we cannot allow just few 1,000 people to be oppressing over 200 and something million Nigerians. It's very wrong. It
takes planning. Now, Angel, back to you. You know, the planning that this man used in executing this, that is Sim Fubara, the governor of Rivers State. He did not just wake up one day to deal with this. Their most plan, he learned from Wike. Wike dealt this kind of blow to Amechi.
Yeah, exactly.
You understand me? So now Wike trying to take control of everybody.
Even Clark, an elder statesman, said he's an emperor during his own time. And you know, when somebody is perpetrating evil, he wouldn't want the next person to deal with him the way he dealt with others. But the more you are doing it, the more the next person is learning from you without even you knowing it. Because this governor now was his chief of staff, Abi his accountant general, either of the two. He was one. So he was his managed person. He was learning and he learned fast. You are even mentioning the things that he removed this person, removed. You even forgot the national, their state assembly. Got fire, got burnt. You understand? So the issue is, where will they even sit to impeach him?
Well,
that is the major thing. He learned fast from his master, and we can need to stop because his integrity is at stake. Because I don't see the reason why you gather all the money, but when your name is mentioned, people spit.
Okay, Angel.
It doesn't make sense.
I was talking about the reasoning and how this man executed this very particular coup, so to speak. You understand?
Most of them were put in there by Wike.
Yes.
So he has to remove them and put his people that will obey him.
Yes, I'm talking about the planning, that it doesn't happen in one day.
Exactly.
That this man would have planned this thing for a while to be able to execute it successfully.
Yes.
Of course.
He executed it successfully. So which means that there have been plans put in place. The execution becomes easy. Now, yes, the execution becomes easy. So this means that we have learned our lessons from the INEC. You understand? I'm talking to obedience now. We have learned the tricks of INEC, and we have learned the tricks of the tribunals, and we have learned the tricks of the Supreme Court.
Exactly.
So inevitably, if we plan well, now going forward, we can beat them to it. If anybody had believed that it is not possible that Fubara is going to beat Wike to his game, then you have seen it happen.
Exactly.
We can beat these politicians. We can beat them on their game. Yeah. We know we can do it. With this one, also our time don't begin to give us signal. Signal make we for carry our car begin to come out for studio. So Angel, make you for greet our people, make them for like and subscribe, make other people know what's in the happen.
Thank you so much, my lovely and intelligent, obedient worldwide. We appreciate you, all your efforts. We thank Ona so much. Yes, one good turn deserves another, and one bad turn also deserves another. Wike is reaping the fruit of his evil deeds. This is just the beginning for him. Exactly. What he did to our PO, he will repeat and cry tears. Not only tears, he will shed blood, and no one will come to his aid. Yes, this is just the beginning for him. Very soon, he won't even step his foot in that river state. It will be out of bound for him. We appreciate you. Like, subscribe. Let all the obedience they hear waiting they happen. Same wicked on the cry small. Oh yeah, begin to like, subscribe, make all the obedience here. We appreciate you. We love you. But God loves you more. Bye for now.